Hello, everyone, and thank you for joining us for today's webinar to discuss global mobility issues, working from home and termination in times of COVID. My name is Annie, and I will be facilitating this session for you today. So today's presentation will be given by a set of panelists, all from different Latin American countries and members of Ius Laboris. We have lawyers from Colombia, Argentina, Chile, Peru joining us today. Okay, that's all from me. I will now turn over to Catalina Santos from Colombia. Go ahead, Catalina, you are welcome to start.
Thank you very much, Annie, and thank you very much, everyone, for joining us this morning, afternoon, if you're in Europe. Today, we will be exploring how COVID-19 has been affecting employment and immigration matters in Latin America. And specifically, we will be addressing these issues in specific countries. And for this, I'm very lucky to be with partners from our very notorious members in Chile, Argentina, and Peru. So today we will be also speaking with Marcela Salazar, partner at Munita Olavarría in Chile, Germán Capulat, partner at Funes de Rioja in Argentina, and José Antonio Valdez, partner at Estudio Olaechea in Peru. So without further ado, Annie, if you could please help us with the slides of our presentation. And the first issue that we will be addressing, I don't know, and yes, thank you, is those matters related to mobility, because after a very restricted year in traveling, the countries are slowly trying to create or to open their frontiers and their borders to travelers again. So for example, in Colombia, if we can go please to the next slide, we have established a protocol for travelers, and basically we have adopted a biosafety protocol for entering and leaving the country. This protocol includes some of the following requirements, among others, such as, for example, travelers must fill out an electronic form, which is known as CheckMIG, before entering Colombia, and this can be done between 24 hours and 1 hour before the trip. Travelers must comply with distancing and hand disinfection rules. There are also some automatic migration or biomic services that have been enabled for previously registered travelers. And there is a very interesting discussion regarding the PCR test, because initially it was mandatory. It was mandatory for travelers to have a negative PCR test. However, this requirement was lifted. So right now there is a debate whether this is an obligation or not. So we are still waiting on our authorities to define this obligation. Just can go to the next slide, please. With regards to international air transport has restarted operations gradually in compliance with those biosafety protocols I mentioned before. The Ministry of Labor has, of Transport has stated publicly that the first roads to be activated would be the US, Ecuador, Mexico, Bolivia, Brazil, the Dominican Republic, and Guatemala. However, we've seen that additional routes have been silently reactivated based on reciprocity and bilateral agreements. From an immigration perspective, most immigration processes have been reactivated. A foreign national can request an electronic visa either through a consulate abroad or through the Ministry of Foreign Relations. However, our immigration institutions are operating only like 30% at their capacity, so there are substantial delays in obtaining appointments. So this is the panorama in Colombia. But I would like to ask now, Germán, in Argentina, how are these mobility panorama or the scenario in your country currently? Germán, welcome.
Thank you very much, Catalina. In Argentina, the national government tried to implement several measures trying to avoid the spread of COVID-19. Internal flights have been suspended from the 20th of March until mid-October, when the Ministry of Transport authorized them, but limited to essential workers and people who need to travel for medical reasons. Regarding international flights, from the 20th of March, international flights were suspended. Only repatriation flights and flights with special authorization from the National Civil Aviation Administration were allowed. Since September, although Argentina has planned a series of frequencies to Europe, the United States, and Latin America, These are still services that continue to be specials. But the big measure in our country was taken on the 16th of March when Argentina closed its borders for non-resident foreigners. The general rules is that until the 20th of December, only Argentinians and foreign nationals with residence in our country are entitled to return. Nevertheless, the government grant some exceptions for foreign nationals with specific authorization from the immigration offices. Essential workers such as technicians and some professionals could apply for a consular visa abroad as soon as the immigration office grant them an entry authorization. From the end of October 2020, tourists from the neighboring countries like Brazil, Bolivia, Chile, Uruguay, and Paraguay has been entry authorization to the Buenos Aires and metropolitan area with a negative PCR COVID-19 test result issued within the last 72 hours and a medical health insurance. And since the end of November, Immigration Office authorizes the entry to non-resident foreigners who are direct relative of Argentinian with some limitations. Since mid-September, we also have new protocol for airlines. Before boarding, the airline must check the temperature of every person, crew, and passengers, and those who have a temperature higher than 30.5 degrees Celsius will have to postpone their trip. Another new entry requirement has been in place since December the 6th. Now all travelers must submit an electronic affidavit within 48 hours before boarding. The form is available at the Argentina Immigration Office website. But the new measure was introduced regarding the PCR test with a negative COVID-19 result that has to be issued within the last 72 hours before boarding. This has been implemented as a new requirement and for any traveler entering Argentina. This is quite good news because we don't have to comply with a 14 quarantine period that was in place until last week. The Argentine authorities also strongly recommend to use a COVID-19 application called Cuidar within the 48 hours of arrival to our country. And another requirement for non-resident foreign nationals is to provide a medical health insurance that covers COVID-19 hospitalization and isolation during the entire stay. It has to be mentioned that additional requirements or authorizations may be required by different provinces in Argentina. For example, from tomorrow, 15th of December, if you travel to Buenos Aires city, in addition to the PCR test issued within 72 hours before boarding, another rapid PCR test will be taken at the Ezeiza International Airport upon arrival. These are the situation in Argentina now. Thank you.
Thank you, Germán. And it seems like there are going to be changes soon, so it's important to keep in touch with you guys to see what's going on in Argentina. Now, Marcela, good morning and welcome. What's the situation in Chile?
Hi, thank you, Catalina. And thank you, Germán, for the status of the situation in Argentina. Chile has relaxed the border closure imposed in March 18 in the context of the coronavirus 19 pandemic. In fact, the government eased some of the restrictions on entering Chile and reopened its border to non-resident foreigners from November 23. Non-resident foreign nationals are not now allowed to enter Chile, but only through the Arturo Merino Benitez International Airport, and they need to comply with some requirements. First, they must complete an online sworn affidavit, same as in Argentina, of their state of health up to 48 hours before boarding the airplane entering into the national territory. This affidavit is mandatory to enter the country and will be reviewed by the health authority at the airport. Second, they will also have to be subject to a 14-day period of vigilance for travelers. During this period, travelers will have to report their location and health condition daily to the health ministry through an online system. In addition, they must provide a negative PCR test result. The test must have been performed a maximum of 72 hours before entry to Chile and must have been carried out by a recognized health authority laboratory in the country where it was conducted. Finally, they must have health travel insurance that covers emergency medical expenses, repatriation for medical reasons, or death, and it also must include coverage for any expenses related to COVID. The minimum coverage must be of $30,000 US. Both the PCR test result and the medical insurance certificate must be attached to the sworn statement. On the other hand, Chilean citizens and residents of Chile are allowed to enter through airports, land, and sea border crossings. They will also have to complete an online affidavit and will also be subject to a 14-day period of vigilance for travels. They must go under a mandatory 14-day quarantine period upon their arrival. However, this requirement can be lifted by the health authorities if they are provided with a negative COVID test result. Same as before, the test must have been performed a maximum of 72 hours before entry to Chile and must have been carried out by a recognized health authority laboratory in the country where it was performed. If the COVID-19 test is performed in Chile, the person will be authorized to end the quarantine from receipt of the test result. Moreover, from December 7, 2020, any person who enters from abroad, regardless of their nationality, place of origin, or destination region in Chile, may be randomly selected by the health authority at any time of entry to submit a direct detection test for COVID. If a Chilean citizen or a resident of Chile does not agree to take the exam, he or she must remain in quarantine for 14 days after entering the country, regardless of the negative result that a COVID test may have been taken either before or after. In the event that a non-resident foreign national refuses to take the exam, the provisions of the sanitary code or the international sanitary regulations will be applied to that foreigner. So that's the current situation. Now I pass over you again, Catalina.
Thank you, Marcela. Very interesting. Actually, I was just receiving some comments from an associate at my team who is traveling to Chile for Christmas. So this is actually very useful. Jose Antonio, good morning and welcome. Tell us how's the situation in Peru?
Hi, Catalina. Hi, Marcela, Germán. Good morning, good evening, good afternoon. I don't know who are connected to this webinar. Well, in Peru, as I think all the countries closed the borders very beginning on March of this year, March 16. And since October, the country start open the borders gradually. At the beginning, we start open the borders with Colombia, with Quito, Bogotá, Quito, Santiago, and that's it. Then in November 1st, we open the borders and we can fly to other countries, Toronto, New York, Washington, South America. Most of the countries, no more than 8 hours of flight. Recently, tomorrow we can fly to other countries, to Europe, basically, to Madrid, Amsterdam, London, and Barcelona. The restrictions are very, we just have a few restrictions. We have to present a health affidavit. We have to have a PCR negative test. And we have to fly with a mask and face shields. That's it. I think that the most important thing, if foreigners come to Peru and comply with this provision, you can move inside Peru. You can travel inside Peru. You can take a local internal flights. But many persons who want to go outside Peru, as for example, tomorrow will be open the flights to Madrid, for example. But Peruvians cannot enter into Madrid. just except in specific cases. So we must be very aware that the airplanes will fly, but doesn't mean that we can fly and enter into the countries, because we have to check if we are able to enter into the country. For example, Peruvians cannot enter into Madrid, except you have a residence, if you have a permit, a work permit, or if for some specific reason that the Spanish legislation is fixed. It's the same with Toronto. Toronto, the airplane will fly to Toronto, but doesn't mean that anybody can fly to Toronto. No? So we must check before we take an airplane if we can go and enter into the country. Thank you, Catalina.
Thank you, Jose Antonio. And that's actually very good advice, not only checking what your own country's requirements for travel are, but also to the country where you are traveling, because right now many countries are continuously changing their requirements for entering each of the countries. So you must be aware of requirements, not only from the country you are traveling from, but also to the country you are traveling to. So I think this is a very wide opening scenario of what's going on regarding mobility, which is probably one of the things that was a most dramatic change during 2020, and that is that we couldn't or we weren't able to travel, but there were also some other changes in what was our normal life before COVID-19, and that is the way we used to work. Annie, we could please go to the next slide. And for this, we're going to talk about working from home. Because working from home was, in some countries, a possibility that was provided by law, but not very common and not very used. But suddenly, all the countries had to go to this scheme directly without any type of preparation. So we've seen many important changes in these types of regulations. And if we go, for example, to the case of Colombia, Annie, and if you can go to the next slide. We had several discussions because we do have different figures that could apply in these cases. So we did have, for example, a telework law, which was in force since 2012. However, requires from several formalities and several requirements that had to be complied with. And within these requirements, we find that there had to be a written agreement, that it had to be voluntary and reversible, that the company had to adapt its internal rules, including a special chapter for telework. The employer had to provide adequate working tools, including, for example, reimbursement of internet and electricity services. There were specific limits on working hours, and there is also an obligation of registering this type of work with the Ministry of Labor. When Colombia declared the lockdown in mid-end of March, probably 98 or 99% of the companies did not have telework in place and did not have all of these requirements fulfilled. So the Ministry of Labor authorized the use of a different figure, which was work from home. Work from home is an occasional, temporary, and exceptional situation, which means it is not teleworking. And since it is not teleworking, it does not require the fulfillment of the conditions that I just mentioned. So for the adoption of a work from home arrangement, there had to be an agreement between the employer and the employee, and that's it. However, this situation that was supposed to be occasional and temporary and exceptional has already extended for more than 9 months. So right now there are several bills of law at Congress establishing the obligations, or at least the requirements and the conditions that employers and employees must fulfill when using the figure of work from home as opposed to telework. So this is a very interesting discussion that right now we have in Colombia, and I'm sure this is the same situation in other countries in Latin America. So Germán, tell us about telework in Argentina. That I understand there's a new law and several challenges for employers in this regard.
Yes, we have a new law from teleworking. But basically, working from home, as you already mentioned it has been defined as a working arrangement in which a worker fulfills the essential responsibilities of his or her job while remaining at home, using information and communications technology. normally working from home arrangement, as you mentioned it as well, are implemented on a voluntary basis between employers and employees. In the current situation, however, working at home has been mandated in many parts of the world as a temporary public health measure. In Argentina, by March 17th, the Argentine Ministry of Labor recommends employers to reduce the presence of workers in the workplace and to implement teleworking. 2 days later, we have a decree establishing a lockdown in the whole country, and in Buenos Aires city and metropolitan area, this was in place until November the 8th. As a result of that, employers have had to implement working from home arrangement to achieve continuity of service, maintain productivity, and preserve jobs while safeguarding the health and safety of their employees. It's important to note that while advances in information and communications technology have enabled working from home, not all job functions and tasks can be done outside the employer's workplace. The situation is exactly the same as in Colombia. Some companies may have previous experience in implementing working from home arrangement, but in Argentina, the majority of companies have implemented working from home arrangement for the first time as a response to the COVID-19 pandemic. In many countries in the world, by July the 30th, Argentina have a new law regulating telework. This law will be subject to further regulation by the Ministry of Labor. The law requires voluntary agreement in writing to be transferred from an office-based employee to telework. And the law have some new rules that has been highly criticized. For example, regarding working time, the law says that working time must be agreed in advance and in writing, that it is quite normal, but it has been highly criticized that the platforms and the software used for teleworking mustn't allow the connection of the worker outside the working hours. The teleworker will have the right not to be contacted and to disconnect from digital devices and or ICTs outside of the working hours and during leave periods. Teleworking law also provides that teleworker cannot be required to perform tasks or receive communications by any means outside working hours. And this norm has been highly criticized, and we expect that the regulation from the Ministry of Labor try to soften this law in this respect. Regarding reversibility, as well, the teleworker may revoke the consent given at any time during the employment relationship and with no prior notice, and the employer must reinstate the teleworker in the previous workplace or provide another closest to the worker homes unless it was impossible to comply with this obligation for justified reasons. Tools, equipment, supplies, and technology must be provided by the employer to the employee. Regarding expenses, the teleworker will have the right to compensation for higher expenses in connectivity and some services. As I mentioned before, the law has not been regulated yet, and we are waiting for the regulation to be published very soon by the Ministry of Labor. Well, this is the situation in Argentina now.
Thank you, Germán, and let's hope the regulation is, well, friendly for employers, because I think it's really helpful to have this possibility. Marcela, tell us how's the situation in Chile?
Yeah, we'll finally have a law on remote working and flexible conditions. After it has been sleeping for years in our Congress, they passed it over and came into effect on April 1st this year. The law provides legal protection to employees who work from home or from places different from employer premises. Employees working from home are entitled to all the labor rights established in our labor code. Pursuant the law, remote work must be agreed between the parties by the execution of an employment contract or an employment contract annex. And the employer is required to register this contract in which remote work is agreed before the labor inspectorate within 15 calendar days as of the moment in which remote work was agreed. The law establishes some minimum requirements or stipulations for this employment contract or annex, such as the place in which the services will be rendered, which may be at the employee's premise domicile or at a different place, the type of remote work, which could be total or partial. It also must contain a working schedule regulation, the control mechanisms, which will be adopted by the employer to supervise its employees regarding the provided services, the term in which remote work will be enforced. And also, those who are excluded from working schedule limitation, the right to disconnection must be included. The right to disconnection must be of at least 12 consecutive hours on a 24 period, in which the employee will not be obligated to reply communications, orders, or any other requirements from the employer. So this is very innovative, and it's very similar to what they have in France. In terms of health and safety, employees working from home will be totally covered by the work accident and professional diseases statutory insurance. The employer has the obligation to inform to the employees about the health and safety conditions associated to the work, including the risk to which the employee will be exposed while rendering services on a remote basis. However, the employee may not enter to the place in which the employee renders services without its authorization, even if the employer's reasons for entering are the working health and safety conditions of the employees. For this purpose, the employer must request to the Mutual Aid Fund to investigate the conditions. Additionally, the employer may also request the Labor Inspectorate to investigate. Nevertheless, the consent of the employee is necessary. The employer must also provide to its employee or pay all the tools, elements, office supplies, and costs associated to the performance of services. Employees cannot be forced to use their own items. Regarding union information, the employer has the obligation to inform the employees about the existence of new unions that have been formed in the company, and employees have the right to access the employer's facilities to participate in any union activity, even if they're working remotely. In connection with termination of this work modality, it must be considered if it was, you have to make the difference, if it was agreed after the start of the employment contract relationship or not. If remote work was agreed after the start of the employment contract relationship, either party may terminate it unilaterally and decide to return to the previous working conditions with a minimum period of 30 days notice. On the other hand, if remote work was agreed at the beginning of the employment contract relationship, both parties must expressly agree to adopt the modality of on-site working. So those are the news for our country. And Catalina, now I'll pass over you.
Thank you, Marcela. And this is very interesting because I've seen that both in Colombia and Argentina, there are also reversibility provisions, which is something that is actually discouraged many employers, because once they have implemented all of this, for having an employee coming back could be a burden. However, Chile at least defines a previous period of time, which is not the case in Colombia, and I would think it's not the case in Argentina either. So now let's move on to Peru, Jose Antonio. How is this situation regulated under Peruvian law? I think you're on mute, Jose Antonio.
Yeah. Okay, sorry. The teleworking in Peru exists, the teleworking law for many years, but really nobody used it because was very many restrictions, and one of the most important restrictions is that the companies are responsible for the health and safety conditions on the house. So if in Peru if the employer is responsible for the labor for the safe conditions on the office, on the premises, imagine that you have 30 people working doing teleworking. According with the law, the company, the employer is responsible what happened in the houses of each of these 30 people. So that's the main reason why this system of teleworking doesn't work really. As consequence of the COVID, the government has to publish a special regulation for remote work. No? In this case, this circumstance of responsible of the employer for what happens in the house of each employee doesn't apply. So that's the main difference. And the other difference is this is a temporary regime. This temporary regime of remote work is valid until July 31st of 2021. This the regime was extended because at the beginning was until October, then December, now July. The company does not have to reimburse the expenses of the electricity, computer, whatever. In the teleworking, the company must reimburse expenses. In the teleworking, in the remote work, the company does not have to provide the computers or whatever, the IT instruments or tools to do the work. In the teleworking, it is necessary. And basically, that's the difference. No, the difference is that the remote work is more friendly for the employers, and the teleworking is more strict. And the big difference is regarding the health and safety conditions. That's the most important restriction for the teleworking in Peru. Thank you, Catalina.
Thank you, Jose Antonio. Yeah, I think there are very similar regulations in our countries. However, I think that not all companies were as lucky of having the possibility of sending all employees to work from home. Many companies are struggling to survive. Many have been impacted by this situation because of restrictions of going back to work. So basically, many countries have aimed to establish some types of prohibitions or restrictions related to some difficult decisions with employees. And for this, Annie, we can please go to the next slide. And we're going to see what our countries have established regarding termination or even suspension of the employment agreements. Because as I said before, many countries have tried to protect employment as much as possible. Some of these situations has been done through prohibition. So in the case of Colombia, and we can go, Annie, to the next slide, termination and suspension rules continue in force. We did not have any type of modification or prohibition regarding terminating employment agreements. Employers are still allowed to terminate employment agreements without cause, paying a statutory severance payment. However, there are special considerations when there is a violation of a fundamental right. For example, if with a termination, I am leaving an employee and the whole family without any type of means to survive, probably a constitutional court judge could order the reinstatement in order to protect this specific case, but those are situations that are reviewed on a case-to-case basis. Termination of employment with cause and based on disciplinary grounds continue to be enforced as long as all the disciplinary procedure is followed and all the guarantees and defense rights of employees are respected. On collective dismissals, however, and even though the law has not been modified, if there is an authorization from the Ministry of Labor required, that those terms or those procedures are currently suspended, so probably you are not going to get an authorization from the ministry at the time. So many companies are opting for termination plans in which they offer separation packages to employee, and so in these cases, the termination of employment is done through a mutual agreement. But I don't know, I think this is not the situation in Argentina, Germán. What's the situation in Argentina for these cases?
Here, as you know, the situation is worse. Our employment law has some rules for these specific cases of economical problems, force majeure, but Since the 31st of March, the government issues a decree saying that employees are prohibited to dismiss without cause and dismiss employees or suspend them due to lack or reduction of work or force majeure. This prohibition was originally established for 60 days. Although some countries have adopted similar measures, only Argentina has extended this restriction. Now will be for 300 days. It's going to end at the end of January 2021. Those dismissals and suspensions that occurred during the prohibition will have no effect, and the existing employment relationship will remain in place according to their current conditions. So the employee could apply for reinstatement to be paid all the salaries during the suspension or the dismissal. In addition to that, since December 2019, the government issued another decree saying that if a worker is dismissed without cause, companies will have to pay double severance compensation. And this measure will remain in place as well until the end of January 2021. So taking into account the current complex legal framework where you have double compensation and the prohibition of dismissals coexist, companies have had opened voluntary separation programs offering employees a generous compensation packages to leave the company. In terms of suspensions, it can be agreed individually or collectively with approval of the Ministry of Labor. The company has to pay like a compensation, but it has to be negotiated with the unions. We said it's not the full salary, but it's around 75% of the salary. This suspension has been working, but you need the agreement with the unions and the approval of the Ministry of Labor. And in Argentina, we also have a legal procedure for massive layoff that it has not been officially prohibited, but the Ministry of Labor decided not to authorize these procedures during the pandemic. So basically, this is the situation in Argentina now.
Thank you, Germán. So we go from Colombia, which is still fairly flexible, to a strict prohibition in Argentina. Marcela, how is the situation in Chile?
Well, since March 2020, there are some restrictions in Chile in order to terminate unemployment contracts. Even if they're not so strict and expensive as in Argentina, they pose some difficulties to employers. In fact, according to our law, the employment contract cannot be terminated due to force majeure or unavoidable event, while the state of catastrophe is still in force. As recently announced by our president, the state of catastrophe will still be in force until March 2020, and however, it could be also extended for another 90 days. In addition, the employer is not allowed to terminate an employment contract due to company needs or termination at will, only in those cases where the employment contract has been temporarily suspended. In this connection, currently, there are two ways to suspend an employment contract in Chile. The suspension of employment contract relationship by the sole operation of the law during the effects of a governmental measure due to COVID-19, which involves the suspension of the company's activities in all or part of the country, and that prevents or totally prohibits the provision of the services. And it could also be suspended on a temporary suspension if they are mutually agreed by the parties. In fact, the law establishes the possibility of mutually agreeing on temporary suspension of the employment relationship when the activity of the employer is totally or partially affected. In these cases, as I mentioned, the employment contract cannot be terminated in Chile. Nevertheless, the employer is still able to dismiss an employee for any cause related to misbehavior, misconduct, or breach of the labor contract obligations, which include but are not limited, of course, to sexual harassment, labor harassment, employee's absence from his or her duties, serious non-compliance of the obligations undertaken in the employment contract, among others. Moreover, the employment contract could also be terminated by mutual agreement of the parties, employee's resignation, death of the employee, in case of expiration of the agreed term, and in case of conclusion of the work or service that gave rise to the contract. For those employees whose employment contracts are not temporarily suspended, the employer may terminate them on the grounds of the company needs or termination at will. In terms of procedure, there are no changes. The employer must prepare a termination letter and then it deliver it to personally or by certified mail to the employee's domicile. The employer must indicate in such notice the grounds invoked and the facts these are founded upon. And the employer is also required to enclose with the termination letter the relevant Social Security contributions receipts. The communication must be delivered or sent within 3 working days of the effective termination, and a copy of such termination must be sent to the Labor Inspectorate within the same term. So that's our restrictions currently in Chile. Now I'll pass over to you, Catalina.
Thank you very much, Marcela. And going up north again, Jose Antonio, tell us how is the situation in Peru regarding termination and suspension of employment agreements?
Thank you, Catalina. Can you, I need the next slide. Okay. Look, in Peru, the situation is very similar to other countries, but in Peru, we have a very specific situation that is that we can also only dismiss employee if the employee commit serious offense, criminal conviction, or disability of the employee to work, okay? If you dismiss an employee for different reasons, without any of these legal reasons, the employee has the right to claim the severance payment that is equal to 1.5 monthly salary per each working year with a limit of 12 monthly salary, or the employee has the choice to request the reinstallation, okay? So if you dismiss an employee for because you have to reduce the cost of reduce the cost of the company, and you just dismiss the employee has the choice to request the reinstallation on the job. So, but in Peru we also have a regulation that allow the employers to suspend the labor relationship, okay? The general rule was in case of force majeure or the force majeure, that's the general rule. When it happens, the event happens, the company can just communicate to the employees the immediate suspension of the labor work, and communicate that situation to the labor authority. But the government create a specific regime for the COVID, and they establish different rules and create a parallel regime. The general rule allows the employers to suspend the labor relation only for 3 months. After the 3 months, and if continue the cause of force majeure, you can terminate the labor contract. But in that case, you need that the company have almost disappear. It's not this force majeure is not for this case of COVID. When the government enacted this specific regulation, I assume that they tried to not give or authorize the suspension of the labor relationship. But at the end, and during for many months, the government rejected this request to suspension of work, and many companies has to continue paying the salaries. As consequence of the COVID, and the COVID continue with us, the government changed the strategy and allows the suspension of labor relationship. And if you want to terminate the labor contract, and because the company cannot continue working, the best advice is that the company must negotiate with the employees the termination of the labor contract. Because if you want to terminate, to get an approval from the labor authority to get the termination of the labor contract, probably you never get that authorization. It's sad, but it happens in Peru. And I never seen that the labor authority approve the termination of labor contract for force majeure or economical reasons. I've never seen that.
Yeah, absolutely. That's the same situation in Colombia. Probably they're trying to preserve as much as possible employment and keeping it until, at least for now, as a liability for the employers. So with this in mind, we're going to go to our final question, and that is, how do we envision employment measures for 2021? Because unfortunately, at least that's the case for Colombia, we are not going to be the first in getting vaccinations, so the effects of the pandemic will continue to happen during at least most of 2021. So what do we have in the agenda for 2021? And at least in the case of Colombia, we have several topics in mind. The first critics, at least the criticisms that have been made by the employers associations, is that working time regulations should be more flexible. Right now, I mean, they're trying as employees are going back to work and the economy is being reactivated, they're trying to get more flexible regulations regarding working time, and especially trying not to pay so much surcharges when employees go back to work. Also trying to reduce labor costs so that formal work is also increased. And this implies, for example, that minimum salary or fringe benefits should be fixed or set in accordance to the industry, to the size of the company, to the region of the country in which this employer is located, for example. Also, trying to regulate other forms of work, such as gig economy, other types of collaborative work, meaning that these individuals, even though they're not formally employees as such, do have some protection, especially from a social security perspective. We are also, as I mentioned at the beginning, trying to pass some laws related to work from home, but those are really related to the topics that I mentioned before. But I don't know, Germán, in Argentina, what is your government planning for 2021?
Well, in Argentina, regarding mobility, and now we are opening because the summer season is coming, and tourism is only opening to neighboring countries, but for sure it will be open soon to all international tourists. But for sure, when the summer ends at the end of March 2021, we will have again new restrictions and lockdown measures for sure in Argentina, as we expect to enter into a second wave of COVID-19 cases. Regarding teleworking, next year for sure we will see more legal conflicts related to the return to the workplace, reimbursement of expenses, health and safety and discrimination claims, some issues relating data protection and security issues for sure as a result of the working from home arrangement. We have to bear in mind, in addition, that in Argentina during almost the whole 2020, schools were closed. And this have had an impact in employees with childcare responsibilities. These employees may want to keep working from home, and this could be a potential conflict with their employers who may request their return to the workplace. For next year, what we are waiting is the regulation of the law for teleworking. We have had access to a draft of this regulation. We can see that it will try to improve some highly criticized aspects of the law. Finally, regarding terminations or suspensions, we believe that it will be very difficult for the government to maintain the prohibition of dismissals and suspension due to the lack of work or force majeure during 2021, because it will happen anyway due to the closure of the company. So we expect that this will not continue during 2021. Regarding double severance compensation, it could be extended for sure during 2021, that probably reduce the amount that the employee will have to pay in case of dismissal without cause. as it happened before in Argentina with similar measures adopted after the 2001 economic crisis. Another thing that we would like to mention is that the national government during all this period has been subsidizing 50% of the salaries of more than 2 million workers in the private sector through an emergency assistance to work and production program known as ATP that will be replaced by another program called REPRO, but the system with the new program will be reduced to a fixed sum of 9,000 Argentinian pesos per employee, which represents 50% of the minimum wage salary. We believe that small and medium-sized firms will struggle to maintain their workforce. As a result of that, we expect massive layoff and insolvency and bankruptcy of thousands of companies in Argentina. Finally, we may see some intent of having a broad social agreement between employers, union confederation, and the government in order to have some previsibility for the future and to reduce the conflictivity that may follow their current economic crisis. This is the situation for next year.
Thank you very much, Germán. Marcela, how does the Chilean government foresee 2021?
Yeah, what's next for Chile? First, the government has announced that they want to continue with the step-by-step plan, Chile Recovers Plan, which main objectives are employment incentives, investment, support to small and medium-sized companies, and speed and simplification of permits. Regarding employment incentives, they will maintain the economic reactivation measures to encourage the return to work of those employees who have been temporarily suspended.
You just muted yourself, Marcela.
Sorry, I was saying that regarding employment incentives, they will maintain the economic reactivation measures to encourage the return to work of those employees who have been temporarily suspended and also to encourage the hiring of new employees. For those employees, we request the return to work incentive and comply with all the requirements. They will receive a monthly amount of approximately $220 for a 6-month period for each employee that returns to work. Moreover, for employers, they could also request for a new hiring, this hiring incentive of a 50% of the gross monthly remuneration with a monthly cap of $340 for every 6-month period. So that's quite interesting. In addition, if the new hiring involves a woman, someone with disability, or a person between 18 years old or 25 years old, the hiring incentive will be of 60% of the gross monthly salary remuneration with a monthly cap of $370 for a 6-month period. The applications will be open until March 31st, 2020. And that's very good news because they're gonna push up our measures in order to return to work for those employees who have been suspended. We are also expecting to have a new immigration law by 2020, as in the past years, the country has experienced a significant increase in the number of foreigners entering Chile with a tourist visa who ended up remaining in the country legally. The government has introduced an immigration bill which proposes not only to update Chile in this area, because we have immigration policy that dates back to 1975, but also to respond to a potential wave of immigration from other Latin American countries following the coronavirus pandemic. So the main bill's proposals are to guarantee safe, orderly, and regular immigration. It especially considers updating to modern times and the needs of the country, but without losing sight of the rights and protections for immigrants. Some of the key measures include establish a flexible system of immigration categories, reform for temporary resident visas, and the creation of new categories of visas for people who want to work or study in Chile. Finally, we are also expecting for this 2020 is the start of the rewriting process of a new constitution. They have been approved for a majority of Chileans, their rewriting process. So the mechanism that by which this text will be drafted will be a constitutional convention fully elected by popular vote. The election of members of the convention will take place on April 2020, and the convention will have between 9 to 12 months to draft the text. And if the text is approved, it must be ratified by the citizens in a popular votation, which will be, the voting will be compulsory. And if the text is approved, it will lead us to its promulgation. However, if it's rejected, the current constitutional text will remain in effect. In terms of employment law, it is expected that the most significant and important discussion for this new constitution will be based in employees' pension system. So we will see what's next in Chile. Thank you, Catalina. I'll pass over you.
That's very interesting, and probably it's going to be an invitation to other countries in the region. We are in Colombia also facing many challenges to our pension system, and we are looking forward to see what happens in Chile. Jose Antonio, what does 2021 have in the panorama for Peru?
Well, Peru will have a very complicated situation, because 2021 we will have an election, a general election for president and Congress, and we don't know what is going to happen in the next month. What I think is going to happen is the labor inspection will continue. Basically, we have a problem with the labor authority will check if the companies that suspend the labor relationship comply with the restriction, and the labor claims as consequences. Sorry, we will have labor claims with a consequence of many measures the company has to comply. Reduction of salaries, reduction of shifts, reduction of dismissal. We will have a lot of claims about it. We will be very active in the labor courts, and I think we will continue. Employees will continue working from home. I don't know if until July, probably the regime, specific regime, will extend until December, and the most difficult situation in Peru is before the COVID. 70% of the economy was informal. Now I think that 80% of the economy will be informal. So I don't know what is going to happen with the formal job, because if the government will have the courage to amend the complicated regulation we have in Peru. I don't think so, but really Peru have a splendid labor legislation. It's fantastic, but for the 20 people who work in the formal system, the other people doesn't care what happened with this splendid regime, because they do what they can do, and they work what they can do, no? And it's very sad, and it's very. But I don't know if the government will have the courage to change the situation. That's it.
Absolutely, Jose Antonio. And that's a very similar situation as in Colombia. I think your dog also wanted to say something, but I think we're just going to wrap it up here. Unfortunately, we ran out of time. However, if you have any questions, please send it back to Annie or to anyone at Ius Laboris. You can contact us directly, and we will make sure to answer your questions via email or any other way. Thank you very much for our speakers, and thank you very much for all the assistance. Annie, over to you.
Thank you, Catalina. So for further information on immigration and global mobility issues, for example, or on the coronavirus situation, I recommend that you visit our website where you can find updates covering several countries. And for further information on the webinars, you can visit our webinar page where we keep all the recordings and slide decks for all past webinars. So finally, also from my side, I would like to thank everyone for attending today, and thanks also to our presenters for their insights. So with that, the webinar will now be ending. Thank you all.
Thank you.
Thank you. Bye-bye.
Bye.